You know when you're relying on someone and they don't show up? It's pretty annoying, isn't it? But what if the person you were relying on was the police? And what if not showing up was not just annoying, but a matter of life and death?
Joanna Michael was 25. She lived in Cardiff with her children, a boy and a girl who were aged 7 years and 10 months. At 2:29 a.m. on the 5th of August 2009, Jo dialed 999 and desperately told the police her ex-boyfriend had appeared at her house. He had found her with another man. He'd hit Jo, not the first time he'd done that in their relationship, said he was going to drop the other man off at home, and then he was going to come back and he was going to kill her.
Now, Jo told all of this to the police control room, who marked the case as urgent, and rightly so. The police control room passed the message to the local police force, but they didn't mention anything about the threat to kill. The local police force downgraded the case from G1, that's urgent, to G2, which is less urgent.
Now what G2 meant is that officers should respond within 60 minutes, but they didn't have to respond immediately. 2:43 a.m. No sign of the police. Frantically, Jo called again. This time the police call handler heard Jo scream, and the line went dead.
Jo had been brutally murdered by her ex-boyfriend. The nearest police station, in case you're wondering, was 6 minutes away from Jo's house. At 2:51 a.m, the police arrived on the scene. 8 minutes after Jo's second 999 call. 8 minutes too late.
Joanna Michael died in tragic circumstances, but her family were determined that it wouldn't be in vain. Just before I tell you how Jo's family took on the authorities, I'd like to say that I make these videos for interest, not for publicity and not for profit. If you enjoy hearing the legal stories, or perhaps you're just sick of AI voiceovers and like to hear a bit of human error now and then, please click the subscribe button now. It lets YouTube notify you when I release another video. It's completely free, and it really makes my day to know that people are watching and appreciating what I do. Thank you. Now, Jo's family and friends couldn't let her murder be the last word on her life. They wanted to do her memory justice, and to see justice done. 6 minutes of police time could have saved Jo's life. Her family took the police authority all the way to the highest court in the land, the United Kingdom Supreme Court. The police had apologised, but Jo's family wanted more than that. They wanted a legal admission of guilt. They sued the police for negligence.
Now, the reason why Jo's case is significant is because it's not normally possible to sue the police for mistakes they've made in an investigation in the UK. This is an old rule that was firmly established in the 1980s case of the Yorkshire Ripper.
The Yorkshire Ripper, a man called Peter Sutcliffe, had murdered 13 women between 1975 and 1980. The hunt for him was one of the most expensive and badly managed in British history, and the police had interviewed him no less than 9 times over 5 years before they finally concluded that he was the murderer.
The family of the Yorkshire Ripper's last victim, called Jacqueline Hill, claimed that if the police hadn't mismanaged the affair, Jacqueline would still be alive. They tried to sue the police for what is called negligence, just as Jo Michael's family were doing now. But in the Yorkshire Ripper case, it was established by the court that generally members of the public could not sue the police for mismanagement. The court said it would cause too much trouble and be detrimental to policing if the police were always looking over their shoulder, trying to protect themselves from the next litigation claim. Well, Joe's family wanted to overturn this rule, or at the very least, make an exception to it where it was clear that the police had made a mistake.
Now, the judges of the Supreme Court gave the case serious thought. The law on police forces is long and complex, and different judges have reached different conclusions over the years and in different countries. At last, Lord Toulson gave the decision of the court. He pointed out that English law does not generally make one person responsible for the acts of another. Then Lord Toulson said that just because the police force exists to serve the public doesn't mean they can be held responsible if they failed to protect one member of the public from another. It was Joe's ex-boyfriend who committed the murder, not the police. Secondly, the court said there was no sense in making the police liable just because they had specific information about the threat to Joe that she had given on the phone. They hadn't assumed responsibility just by knowing her ex-boyfriend was dangerous. And thirdly, the court said Joe had had no assurance from the police that they would arrive any quicker than they actually did. The call handler never gave a time. They never made a promise, so they never broke one.
Now, this all might make sense in a logical, technical way, and perhaps it kept the lawyers happy. But you can't help but wonder if the average person asked the same question would have reached the same result as the court did. In fact, 2 of the 7 judges appointed to the Supreme Court that day disagreed with the majority judgment. They thought the police should have been liable, but they were outvoted. I imagine that legal technicalities were not going through Joe's brain when she called 999. In fact, I should think the only thing on her mind was fear, and the knowledge that as soon as the police turned up, she would be safe. But they never did. Thanks for watching.